Is our other co-chair, Peter Kosinski, and on my right is Commissioner Andrew Spano. And since the resignation of Commissioner Peterson, that seat remains vacant, and we await the appointment of his replacement.
Yeah, I'd just like to, if I could, just take a minute and note that Commissioner Peterson left at the end of the year and has not been replaced, but we'll miss the commissioner. He's been here since, I believe, 2011, and spent a number of years at the board, and I always enjoyed, of course, working with Greg. He's a great commissioner. He had a long and very storied service in Nassau County and continued it up here at the state level, and I think has decided to return to his roots in Nassau County, but I just wanted to make mention he'll be missed, and I appreciated serving with him.
I think we all share that sentiment.
Yes, we do.
All right, so let's turn to our agenda. The first item on the agenda is the adoption of the minutes and executive minutes from the meeting of December 12th. Is there a motion?
So moved.
Second.
All those in favor say aye.
Aye.
All right, those minutes are approved. So now we'll proceed with the unit updates. We'll start with our co-executive directors, Bob Brem and Todd Valentine.
We were going to ask if we could take the ballot access rulings out of order maybe and do those first. There's two reasons. One, it would help us to get the notices out, and I think one also is
There's one in court right now.
2 o'clock.
Soon in Judge Lynch's chambers.
So at least we could say what we've done, if we could do those first.
All right, well, if everyone agrees, we'll start with the ballot access rulings.
Sure.
We've been given written reports. Let's make sure we're all looking at the same piece
So we
of
have 2
paper.
pages. There are 7 items. 4 with regard to prima facie review, 2 with regard to objections and specifications, 1 that resulted in a hearing, and then there's a sheet with regard to 1, 2, 3, 4, 5, 6, 7, 8 libertarian candidates who applied to be on there.
So let's just briefly go through the rulings. So in the prima facie, you have
The presidential petition with regard to Elizabeth Warren, we received, in addition to a full set of petitions, a 3-page petition, which is insufficient on its face. So that's the first one.
all right, so, but the thing to stress there is that Elizabeth Warren will be on the ballot by the large petition, that this was just this stray, separate petition that's being rolled in ballot.
Correct.
Okay.
That's the same issue on the next one down, issue number 2, a congressional delegate slate that starts with Assemblymember Steck in the 20th Congressional District. There is a full set of delegates pledged to Mr. Sanders is this one. But they've also filed a separate single-page petition with us, so it's insufficient on its face for that 1 page. The third one is a delegate named Pascal in the 2nd Congressional District. The Part A of the chapter that we are under for the presidential requires us to do a prima facie review to ensure they're enrolled in the party and also a resident of the Congressional District. This individual is not enrolled anywhere in the state or registered. So that means that they cannot be on the ballot. The 4th one, Mr. Mensa, is a delegate in the 17th Congressional District. He lives in the 16th, so he's not eligible to be a delegate in the 17th. Mr. Armstrong is a libertarian candidate, filed petitions for president. An individual filed general objections, never followed up with specifications, but the general objections themselves were late, and the individual is not an enrolled member of the party eligible to bring the objection. The next one is Whitmore. is the candidate. It's a Libertarian in Congress District 27 special election. We have a qualified objector. We have a timely notice, but the underlying issues that they're raising are in court. We were served those papers. We sent a copy to you.
All right, just on that, on that issue, the objection, the specific objection raises factual issues that we would have to rule on that ordinarily the board would not get into.
Correct.
Correct.
And so that's the reason. It's not because it's in court that we're not ruling on it. It's because typically we decline to exercise jurisdiction where a fact hearing is required.
That's correct.
Okay.
And then the seventh one is Mr. De La Fuente, a Republican candidate for president. The requirement is to have 5,000 valid signatures. 5,204 were filed. An objection was made. A hearing was held. And the staff recommendation is that the petition only has 4,111 valid signatures, and therefore the petition does not have enough to sustain the nomination.
Okay, so is there anybody here who wants to be heard on any of those 7 items? All right, then I would move that we adopt the report as prepared by the staff.
I'll second that.
Those in favor say aye.
Aye.
Opposed? All right, so the report has been adopted by the commissioners. Now, on page 2, you have a chart of candidates who have applied to be listed on the Libertarian Party presidential primary ballot. And the Libertarian Party has adopted the, selected the alternative procedure in Election Law 2-122B, which provides among the options for getting on the ballot that the commissioners rule that they are nationally known. You want to just summarize the report?
Do you want to?
What the report lists are the obviously the name of the candidate and then the basis of the request that they had asked. And in addition, there's a requirement under that section of law that any candidate seeking on the alternative methods, as you said, would have to file a complete slate of alternate and delegates with their request or by the same deadline as the requesters do. Listed, we had Ken Armstrong listed as nationally known. As we referred to, we did file a petition, and he did file a slate of delegates, but that slate was not filed timely. So we recommend denial. Dan Berman also claimed in his letter to be nationally known. He did not file the required slate of delegates. Lincoln Chafee also requested nationally known, and again did not file the complete slate of delegates. Jacob Hornberger did file a letter as nationally known, did file the complete slate of delegates, and the recommendation would be to approve. Adam Kokesh filed a nationally known letter, did not file a slate of delegates. Sam Robb also claimed nationally known, did not file a slate of delegates. Vermin Supreme, also nationally known, and again did not file a slate of delegates by the deadline. And just this morning, Mark Whitney filed a letter nationally known, which would be both a request and there was no slate of delegates. So the request would be late. It was due on the 25th.
So 7 of the 8 are essentially prima facie invalid
That is
because they
correct.
have not complied with all the requirements of the statute.
That is correct. That would be the recommendation.
And then Jacob Hornberger has complied with the statute and submitted evidence of national recognition. The recommendation then is that he be left on the ballot, and he would be the only candidate in the Libertarian presidential primary.
That would be correct.
All right, so I'll move that
Well,
we, go
I
ahead.
just spent a minute going over this then. Okay, so as I understand it, all the delegates applied, or all the candidates applied as nationally known. But the finding of 7 of them isn't whether they're nationally known, it's just they didn't file the delegates.
Yes.
So we really don't have to make a determination of whether or not we would find them nationally known. We're making a determination that the failure to file the delegate list is a fatal flaw, so they are not eligible to appear on the ballot for that reason. So Mr. Hornberger is the only one who complied with the delegate requirement, and then he has to also establish that he's nationally known. And from what I've seen and been told, he has qualified in a number of states around the country to be on the ballot for their primaries, and is apparently nationally known, at least within libertarian party circles, as opposed to necessarily other circles. But that he would comply as nationally known for those reasons, his eligibility for other state ballots and that reason. So that's the reason he would then be allowed on the ballot. Is that a fair? Okay.
That's my understanding.
Okay, I just wanted to make that clear.
I agree with everything that
Okay.
you reported.
Okay.
Okay, so the motion before us then is to approve this report, which is ruling 7 candidates invalid for failure to comply with the statutory rules, and finding that Jacob Hornberger did comply and is nationally recognized.
Second.
Yep. Okay.
Those in favor say aye.
Aye.
Opposed? All right.
Judge.
All right, are we finished then with the
Yes.
ballot access rulings?
Well, we have one last, and I guess that's the Republican side,
Oh, go ahead.
which I will
Which you
speak
alone
to.
have authority.
I do, and pursuant to the statute, again, the same statute that Commissioner Kellner referenced, 2122B, that is the accessibility to the ballot portion of the Republican Party presidential primary. In that context, the way the statute's written, it's the obligation of the commissioner of that party, in this case me, to make a determination of which candidate or candidates are eligible for the presidential primary on the Republican side this April. In that context, we had 4 requests for access to the ballot. One being from Donald Trump, who requested to be included for purposes of the statute as nationally known, also as meeting the requirement of being eligible for federal matching funds. And he did file a complete list of delegates, and on that basis, he is qualified to appear on our ballot for the presidential primary. The next one is William Weld. William Weld also filed a letter requesting that he be on the ballot. He has filed a request under both nationally known and matching funds. The determination here is that he does meet the matching funds requirement, and he filed a list of delegates, but the list was incomplete. Under the statute, there is a window within which the candidate who files an incomplete delegate list has an opportunity to cure. It's a 3-day window. That 3-day window started yesterday. He was noticed, the campaign was noticed that they did not have a complete list of delegates, and they are given till Monday to rectify that shortcoming. So that opportunity will end at the end of the day on Monday, and then on Tuesday we will make a determination of his eligibility to be a candidate for the presidential primary. That will be really determined based on what their campaign does to cure the defects of the delegate list that was filed at this board earlier. So we'll know by the end of business on Monday, and we will have a public meeting where we will make a determination of William Weld's eligibility to serve, but that will depend on what information this board receives between now and Monday regarding those delegates. Mr. De La Fuente, who was referenced earlier, filed a petition that was ruled invalid. He also filed a request to be included as a nationally known candidate, but again, failed to file any delegates, and thus is ineligible to appear on the ballot. And the final candidate was a Joe Walsh. Joe Walsh had filed a letter with the board requesting he be included as a nationally known candidate, but again, failed to file any delegates with the board, so he again is ineligible to be on the ballot for the Republican Party. So the status right now is that Donald Trump is eligible to be on the ballot, and we will know really end of business Monday, and then Tuesday whether William Weld will appear, and there will be a formal public announcement of the findings of the board regarding that.
And am I correct that the significance is that if William Weld does not cure the defect, then Donald Trump will be deemed elected as the only candidate in the Republican presidential primary, and therefore there won't actually be a Republican
Like all of our
primary.
primaries, there's
Right.
only a primary if there's an
Right.
actual contest.
These delegates will be deemed to go to the convention.
Right. Yes, I guess you're right. The
Slight
distinction here is this isn't for the president, this is for the delegates to the national convention. So you're not actually primarying for president per se, you're primarying to be a delegate. And in the Republican context, it's 3 delegates and 3 alternates per congressional district. So it's a total of 81 delegates and 81 alternates that have to be filed here that meet the qualifications of office, which are that you be a member of the party from the congressional district which you're seeking to be a delegate from. So that's the requirement that each of the candidates has to meet. As I said, Donald Trump has met that requirement, and as of today, William Weld has not, but they're in the process of potentially curing that.
All right, well, thank you. All right, so does that conclude the ballot access issues? All right, so then we'll start with the unit updates and ask Todd Valentine and Bob Brehm to report.
Well, it's certainly been a busy start to the year. We have had a successful January conference with the association. We saw the proposal of the budget. We did make a recommendation during the 30-day amendment period of time in the budget for a amendment to the proposed budget that would fully fund the staff salaries for the state board. We're still, this budget as proposed is about a little over $1.5 million deficient. Most of that's personnel funding and a little bit is technology-related funding. There are some small amounts of leverage left to us that we haven't exhausted this year. For a little bit of maybe leeway, I would say probably not more than $200,000 within whatever's left, which is very little for that big of a number. So we still are facing what could be a 1.5 when you round the numbers issue in the budget. There are other funds that are appropriated. There's $16 million in there for the online voter registration project. Part of that fund would also cover the 20% required local match for the federal Help America Vote Act cybersecurity money. It's a 2020 program. Was signed by the president, I think, on December 29th. New York State share of that grant is about just shy of $22 million, and the budget provides the authority for the state board to apply for and receive that money and to expend it. So part of the application process is a plan, and we worked to prepare a plan for your consideration today so that we can then make application for that money. In addition, the general items that are on the list of things for you to consider, we've all worked hard on. And if I go through my normal litany of what they are, then they'll generally be covered by the units that helped us to prepare them also. So I'll let them give that part of the report.
I mean, the only thing I would add is within the context of the budget is we are exploring, we're planning to add additional space because we've been in a tight space situation. So we are seeking to get additional space in this building on the 10th floor, and we've been working with OGS real estate section to recognize that with the advent of the public campaign financing, when that piece starts to go to fruition, there will not be enough space in this building for us. So we're exploring a new office space that may take over the next year. So we've begun that process.
There was no money in there for the new
office
commission.
space as an addition, or to take the whole thing out?
We would probably move the entire agency.
We're already split on 2 floors.
Okay,
What will be
Two-
three
Yeah,
now?
it makes sense.
it's gonna be
I know.
3 now, so, plus an off-site data storage center. 2 data storage centers, actually. So we're pretty spread out, but we've run out of room. And there's no more, other than the extra space that became available on the 10th floor, there's no room in this building.
Okay, any questions? So we'll now turn to the councils, Kim Galvin and Brian Quayle.
Thank you, Commissioner. I'll start off with a discussion of cases and litigation matters as they stand presently. We have currently 3 pieces of litigation related to either ballot access or ballot access related matters. In Albany Supreme Court, there is a challenge to the Libertarian nomination in the 27th Congressional District related to whether or not the Libertarian Party correctly followed their rules. We also have litigation on ballot access in Nassau Supreme Court related to the Libertarian Party rules generically, as to who actually is the Libertarian Party. And in the Albany County Supreme Court also we have a invalidating proceeding Kim referenced at the beginning related to the De La Fuente petition. And we have several other matters pending in federal court and state court also. Most notably perhaps actually is the state court matters in Niagara County regarding the New York State Public Campaign Finance Commission and whether or not it's properly constituted, and other ancillary matters. We expect a decision on that imminently. Since the last meeting of the commissioners, received a decision in the Common Cause case directing that the list of inactive voters be provided in poll sites in New York starting immediately, and we have moved to comply with that order. The board issued appropriate advice and direction to the county boards of elections to facilitate that occurring, and it will occur. The board was also served and sued.
Brendan, before you,
Brian.
I'm sorry, Brian, before you pass on that, can we just talk about that for a minute?
Of course.
So that case was one about whether inactive voters should be at the poll sites for purposes of having a list available to the inspectors at the poll site of who's inactive. Inactive voters right now are those who are not eligible to vote on the machine, but are inactive because there's reasons to believe they might have moved, and so they are voting on an affidavit ballot.
That's correct. So
Does this change that at all?
No. The case sought a great deal more, but distilled to exactly what you just said. The court ordered that the list of inactive voters be provided to poll workers and poll sites, so that a voter who's on the inactive list, while they would still vote by the affidavit process, just as before, no change, would be able to be aware of the fact that that the board had a record for them, that they were inactivated, so that it would offer that voter some context to why they were voting on an affidavit ballot, and also assist the poll workers in being able to determine the correct course for that subset of voters. It is also true that other voters, for example, voters who move from one place in New York to another place in New York and are eligible to vote in a new poll site by virtue of the fact they've moved in since the last election, they would not appear on an inactive list, but those voters, just as before, are eligible to cast an affidavit ballot, and it would be a valid one. also. So the only fundamental thing that the case changes is that a piece of information that is a voter's status is inactive in a particular poll site in a particular election district must be provided to the poll workers in that election district, and the list consulted by the poll workers at the point in time in which they don't find the voter on the active list of voters. So I think that's a pretty concise description of what it is. I want to make sure. I think you were right to query me because I may have caused people to
No, I
misunderstand
just think
what
it's a
happened.
change that people should understand what the impact is, and that while it changes the process at the board, it doesn't really change the status of the voter themselves. So I don't want voters to be misled into thinking that somehow changes their status. They're still inactive, meaning that they can vote, but they must vote on an affidavit ballot, and then there must be some demonstration that they're still eligible to vote from that address before the vote would be cast.
Yes, by virtue of signing the affidavit ballot and saying that's where they live.
Right.
Yes.
Okay.
And two other federal cases, discovery is continuing. Also in the Sugarman v. NYSBOE matter in which the board received a very favorable decision. We have made a motion in that case for a more specific order. The Chief Enforcement Counsel has responded, and we're awaiting a decision there. I would also note that in the third department, the 60 days to perfect the appeal that is the normal time frame has elapsed, but the appeal is not dismissed until 9 months. So the question is how the board may want to proceed in this context of, again, re-informing the court of the exigency of moving the case along.
So I'm sorry, can we just go over that a minute, Tom?
Yeah.
So you're saying that there was a ruling in the favor of the board regarding the Enforcement Council's obligations to comply with the regulation that's in place?
Yes, and that was, of course, quite some time ago.
Right.
And then at the last meeting, we determined to make a motion for an order that could potentially support a contempt application on account of the fact that the Chief Enforcement Counsel has failed under her obligations under the regulations to file reports to the board of her activities, certain activities.
Court order.
Right.
And so, so in order to be able to potentially pursue contempt remedies, we have asked the court to just issue a more specific order that within its four corners would more easily support a contempt application. And then, and as an aside, I just note that from when the notice of appeal was filed in the third department, it is typically a 60-day time frame to perfect the appeal, which is to file the brief. That has not occurred, but the
And the
appeal,
60 days has expired.
60 days has expired. The case, however, remains alive for 9 months. So as long as the appeal is perfected within the 9 months, then the case can go forward. But a party who would be the respondent, which would be us, is capable of asking the court to compel that filing sooner, so that we don't have to wait for the 9 months to elapse, and that's something the board may want to consider doing. And as far as cases, that's that.
Sam?
Right. I thought I mentioned the Sam case, but the Sam party case in federal court, whether the mechanisms for party status that were adopted by the New York State Public Campaign Finance Commission are valid, was commenced against the board. The board is in the process of retaining counsel, and the answer in that case is due, or a motion is due by March 12th. And then with respect to the compliance unit's metrics, which was an exciting topic, we've had no hearing officer cases for 2020. There were 2 in 2019 and a total of 26 since 2015. We stand at having received 171 emails with paid internet digital advertisements from 94 different independent expenditure committees. And the 2020 January periodic, as of the 26th of this month, there were 3,392 filings that were due that have not been received. And
3,000?
Yeah,
Yeah. 392.
3,300.
That's a record, isn't it?
Yeah, it's a big
It's a
one.
big number. It's a big number. And
Are you finding that your numbers of non-compliance are increasing?
Yeah,
You are finding that?
yeah.
Would you attribute any of that to the failure of the Enforcement Council to pursue failures to file, or?
Well, you can't really say why people aren't filing, but it's certainly, since there's been no enforcement on it, they have increased steadily.
I concur completely. I
So those two things seem to be connected, at least.
You know, the compliance unit is also, starting to panic because 3,300, and that just keeps filers that need to be contacted that, are missing reports for the next report, and so it's flooding the system with bad filers.
think that's it for me.
All right, anything else? Then we'll go to election operations, Tom Connolly and Brendan Woodville.
Thank you, Commissioner. For the presidential primary and the special election, both being held on April 28th, we've been busy lately with a lot of candidate filings. We received filings for 23 candidates for president and more than 700 for delegates and alternates. For the special election, we received filings for both the 27th Congressional District and the 50th Senate District that file here. There are 2 other assembly districts for a special election that file locally. With regard to the voting systems, currently we still have the ES&S Express vote that's under evaluation for certification. The current status of that is that NYSBOE, who is our independent security expert, are presently reviewing the work of SLI, which is one of the 2 certified testing labs. SLI had done a source code review and other review of the Express vote unit. NYSBOE has been reviewing that work in conjunction also with another group called ATSEC. We have SLI is normally the testing lab that we use to review the vendor's testing lab, but since in this case SLI was the vendor's testing lab, we couldn't have them check their own work. So we work with NYSBOE to get an additional set of eyes. So it's kind of just checking the checkers. SLI did provide some additional documentation to NYSBOE last week. NYSBOE has been reviewing that information. They expect to have it done by the end of this week. So we'll be speaking with them at the beginning of the week, next week, to see what NYSBOE's findings were, if there's any additional documentation that may be required for SLI or ES&S to provide. At the same time, from this process, there have been some changes that ES&S is going to be making to their source code. They've made us aware that they have what they call a new code drop that they plan on providing to SLI that addresses some of the issues that have been raised, both by NYSBOE and then just kind of by us in general. That has not been submitted to SLI yet, but once it is, it'll follow the same process where SLI will review the source code, they'll provide a report to us of their findings, and we will have NYSBOE take a look at that to make sure that it is sufficient. We also, recently on Monday, we actually, going back a little bit further since the last meeting we had, it was in December, on January 14th, we held a public demonstration of the Express Vote XL here at the board. That was well attended. One of the requests that came out of that demonstration from Disability Rights New York was that we try to provide another opportunity for individuals with disabilities to have more time to just kind of interact with the system. We did schedule that and held that this past Monday. We had 2 machines set up in this room. We had more than a dozen attendees come. There was an overview given of the voting system. There's an opportunity for individuals to ask questions about the voting system. And then we made sure that everyone who had attended who wanted to interact with the system had an opportunity to try it out. We had it both in tabulation mode and also in ballot marker mode. There was feedback that was given that was good, and also some feedback for some changes that was given to ES&S and Brendan and I, who were here. But overall, I think it went very well. With regarding Dominion, Dominion did submit a modification. It's not much is changing, but they are changing out the printer, the ballot printer that's in the ICE machine, because the printer hardware that's currently in there is they can't find it anymore. They can't buy it. So it's kind of just replacing out the hardware, one printer for another. They added a software utility for the ICE machine that also makes it a little bit of an easier process for confirming or checking the hash values of the software that's contained on the machine to make sure that it is indeed the trusted build that we give out to the counties. And then lastly, they were making a software change to improve image processing on the ICP, the older machine. So they've submitted an application for that modification. We've requested some additional information from them. SLI will be doing the source code review and then the review of any other documentation to determine what additional testing might be necessary. And then, as I've mentioned at the previous meeting, I think, we've been discussing both Heart Intercivic and Democracy Live, our two voting system vendors. They're not presently certified, don't have any systems certified in New York State, but they've expressed interest in potentially submitting systems for consideration. Heart Intercivic would be considering submitting a complete voting system. Democracy Live right now has a ballot marking device that is capable of printing ballots that can then be scanned on either an ES&S or a Dominion system, which are certified systems. I did have a phone call, a little online demo with Democracy Live yesterday as well about that. They're going to be scheduling a little, one of the issues that they had last go around when they came here to show us the hardware was that it would produce a ballot which could then be put onto a scanner, but there was no way for the voter to verify that ballot. It's my understanding since then they've added now a new scanning hardware component to the system so that that verification can take place. I've asked them to set up a demo for Brennan and I, at least video-wise, to see this in use, and then to ask any additional questions we may have before they decide to formally submit their system or not.
Tom,
Yes.
is Heart or Democracy Live, is that the name of it?
Yes.
Are they in other states?
Yes.
Do you know how many other states?
I do not know how many other states that either one is in.
Hart is the third largest vendor in the country.
Yeah, and Democracy Live doesn't. They do the ballot marking device. They don't have an actual voting system itself, like for a precinct, and they do other tools like accessible online ballots and.
But they have been certified for use in other states around the country.
I believe I can't remember if the ballot marking device or Omni ballot product it has, but I believe it has because it's in use.
We can get you a list of that information.
But Hart definitely has been, as Doug said, it's the third largest vendor. So some of their systems have been certified in other states. Otherwise, electronic poll books for No Ink, we do have something on the agenda later on. They did submit a modification to their configuration to include both new hardware. The most recent set of e-poll book configurations, or at least for those that were using Apple iPads, were using the 6th generation. Those are harder to buy now. If you're buying new, they're up to the 7th generation, so it's a new piece of hardware. There's also a new operating system on those devices. So No Ink has submitted a configuration of their application with some changes running on the new hardware and on the new operating system. So we've provided reports and a resolution for your consideration later in the meeting. We continue to work with both other vendors, 10X and Robus, on making updates to their systems. 10X, which also uses the iPad, is looking to submit some modifications to their system to run on the new hardware and the new operating system. They're also looking to add another thermal printer, a small receipt printer to their system, just to kind of replace an older one. Robus, which runs on Windows platform, is looking to update the build of Windows that their system is running on. So we're going to be reviewing that and working with them to get us everything we need in order to kind of do our review of it. As far as other things, we are preparing for the receipt and review of various documents from county boards relating to early voting, as far as the network security checklist, as well as the site security for the physical site security of early voting sites. We continue to work with various units on the campus update, some various cybersecurity projects and updates to the procedures as a result of the legislative changes from last year. We will be providing guidance and holding at least one conference call with counties with regard to both programming the presidential primary ballot and also for those counties that might be holding the presidential primary and the special election on the same day. And we've been working with the Office of General Services, or OGS, on a new voting system contract language because the old one is expiring. So we had a call yesterday. We were discussing various items that we might want to change as far as the language in the contract. And other than that, do you have anything?
No, you're good.
I have a few questions about the express vote certification process. So, what is the current timeline for having a report on the certification application?
It's hard for me to say at this point because we haven't finished completed the first review of the code, and we've already been made aware that there's going to be a second set of code to review, and we haven't been made aware of what the totality of those changes are yet because it hasn't been submitted to us. As far as Brendan and I are concerned, whenever people ask us how long is it going to take, the answer is usually as long as it needs to. So we're going to make sure that, we're relying on our independent security expert, NYSTEC, to kind of review the findings of the testing lab to make sure that it was done. And so we have to make sure that they have everything that they need in order to kind of do their job. So obviously we're looking to kind of move the process along at a natural rate, but without cutting any corners.
What is the earliest possible time when there would be a report ready for the commissioners?
Again, I think it's the same.
If everything clicked and there were no further delays, what would be the earliest date?
I would have to say if everything clicked and the code dropped and they did a review and then we would do functional testing, probably within 2 or 3 months.
And then what documents are publicly available now so that for people who are interested in reviewing members of the public who are interested in reviewing the application so far, what documents would be available to them to request to review?
Well, I think that they could probably request any publicly available testing documents. I think a lot of the reports that we receive both from SLI and or NYSTEC would have to be reviewed just to make sure that there's nothing from a system security standpoint that might need to be redacted. I don't think there's anything necessarily that would be wholesale not provided. It just might require some.
But there have been preliminary reports from SLI
Yes.
and NYSTEC? Okay. And the vendor is required to submit a complete technical data package, right? And has that been complete? Has that submission been completed?
Initially, yes, and then they would most likely have to make some type of amendments when they drop the next
Set of code.
set of code at that time.
Okay. And then Common Cause sent the commissioners a letter, I believe, indicating that they had an objection that the verifiable ballot that would be printed out or displayed by the express vote was only in English. Are you aware of that objection that they've made?
That came out of, actually, Susan Lerner was here on Monday at the demonstration that we held for the disability, the individual with disabilities. There was a question that was raised about the supportive languages and what languages were displayed in various parts on the screen. The answer that was given from ES&S was that although there may be potential for some support as far as on the paper of printing English and Spanish, that was the extent of what they could provide as far as languages go. Now, the system itself does provide support for additional languages, but unlike, for example, in New York City, where one might receive a ballot that contains English, but then also additional languages like Chinese or Bengali, and the voter who would need that translation might be able to see the information in that language on the screen of the Express Vote Excel. The actual paper document, which is being tabulated, only contains English. So they would, if they are unable to read English, they would be unable to verify the contents of that piece of paper.
And is the vendor arguing that that complies with this New York statute that requires a voter verifiable paper audit trail?
I don't know if I would want to speak for the vendor as far as that, but I mean, like I said, this kind of just came up on Monday.
Or is that something that should be pointed out to?
No, yeah, absolutely. We've actually had some staff on from ES&S on site this week since that demo, and we've been working with them some of the things that came out of that meeting and also other things that we've been noticing.
And I appreciated your report on other vendors who are considering submitting applications of equipment for certification. Do the counties realize that the vendor really doesn't have an incentive to seek certification unless the counties have indicated an interest in purchasing the equipment?
Well, I don't know if it's just the counties that do this. I think the general public has a misconception on how the process works in general, but we're, as we've said from the, get-go, we're interested in talking to any of the vendors that, certainly want certification, for their machines in general. I don't know what conversations that either of these vendors have had with any of the county boards, but
Well, Brendan, so for example, I noticed that there have been some arguments that the current ballot marking devices can no longer be supported, whether it's the ImageCast precinct or the AutoMark. And these other vendors could be offering alternative solutions to that.
yes.
And do you want to elaborate further on discussions between the counties and these other vendors and your office in terms of how this is being pursued and how the certification process relates to it?
Well, I know both of those vendors were at the winter conference and meeting with any of the county boards that were there and showing off, their wares. Obviously, neither Democracy Live nor Hart are certified at this point, but they have brought machines in to show the different county boards. To the extent of what their outreach outside of that is, I can't speak to that. What counties they met with. I know that some of them do show up at some of the regional meetings to where a group of counties would get together to do that, much like what the poll book vendors did last year around the initial process once we were doing the approval process for that too. I believe that it was Democracy Live that met with New York City to show off their products for them. We also had a meeting with, when was the meeting with Hart in December?
Somewhere
That we did have an initial meeting with Hart a month or two ago to go over their system, some of the information that they had questions with as well.
But I think generally speaking, I mean, whether it's, at the conferences that are held by the ECA here in the state, like I know Democracy Live was also at the summer conference last year, where if I happen to be somewhere else in the country and speaking with different machine vendors, I encourage them to try to interact with the counties, whether through, like Brendan said, some of the regional meetings or even coming to the conferences to see if there is a potential clientele. I mean, obviously, what we've been seeing the past year or so is around the age of the voting equipment that's out in New York now, there are a number of counties that are looking to add to their fleet or to kind of refresh their fleet. And so I think that's one of the reasons why we have additional interest from vendors as far as potentially going through the certification process, because there's going to be, I think, increasing clientele for them as far as replacing voting systems.
All right, well, thank
Can
you.
I just add one thing? I know that you're talking about the ES&S machine. It may be relevant that Senator Myrie is holding a hearing on that machine itself, right?
I think
He hasn't scheduled it yet. He
Right.
said after the budget. And there's also a bill introduced banning systems that utilize barcodes, was introduced last week. So I know they're paying a lot of attention up the hill as well to this certification effort.
Yes, indeed, because I'm getting many, many phone calls from members of the legislature. Okay, anything else? So we'll go to public information, John Conklin and Cheryl Kauser.
Thank you, Commissioner. The Public Information Office continues to be very busy. We've had a lot of inquiries since the last meeting about the presidential primary. I think as every unit in the building probably is dealing with questions along those lines. E-poll books, early voting, the campaign finance report in January, petitions in general, enrollments. Those are some of the big topics that we have been addressing from inquiries from the public and the press. As Bob mentioned, the Election Commissioners Conference was in January. The PIO unit made 2 presentations there on the national change of address procedures and also on public grants. We also participated in the monthly ECA calls in January and February. We processed 107 foils in December and 148 in January. Excuse me. The unit also assisted in preparing Bob and Todd's testimony before the state legislature's budget hearing. We continue to participate in meetings on online voter registration and the development of that system. We prepared the NCOA files from the Postal Service for the county boards to conduct their list maintenance obligations under the election law. And we participated in a meeting with the school districts, with the New York State School Boards Association and the State Education Department to draft an absentee ballot application for school districts, which is in your packet, I believe, is one of the things you're going to approve today. So with regard to the website, we posted official enrollments on February 21st, which was the new statutory deadline. We posted official results, since the last board meeting, it's been a while, we posted official results for the 2019 general election. We posted updates to the running for office page, the 2020 political calendar. We posted a calendar for the special election for New York 27, SD 50, and the 3 assembly districts, 12, 31, and 136. We have filed ballot access filings, or posted rather, ballot access filings for the presidential primary on the website, nomination filings for the 428 special, the campaign finance filing calendar for 2020. We've taken down some regulations that were no longer up for comment. With regard to NVRA, Michael and Patrick visited Clinton, Broome, Essex, Warren, Oswego, Tompkins, Lewis, and Putnam counties since the last meeting. That's approximately 2,200 miles they've traveled for nice voter board reviews. All counties were found to be compliant. Do you want to talk about the HAVA grants or the grants, Cheryl?
Sure. As of January, agency grant administration has been consolidated under the Public Information Office. There are 5 grants in total. Submission of HAVA operation expenses by BOEs or shoebox, HAVA education and training, New York State poll site improvement, and early voting capital grant and early voting aid to locality scripts. The HAVA education and training and New York State poll site training grants and shoebox contracts are currently being renewed with the applicable counties for the new contract year, which will be in effect April 1st, 2020 through March 31st, 2021. For the early voting capital grant program, contracts were out on April 2nd to the county boards of elections. 1 contract is outstanding. We reached out to the county. They're working on it. We hope that they have that contract in soon. To date, we have 25 reimbursements, 23 of which have exhausted the grant funds in total. For aid to localities, the contracts were sent to the county boards on September 27th. All but 8 contracts have been received. We've reached out to the 8 counties that have not submitted those contracts. Again, some are in county government, different levels. They're working on them. They're aware of it. And we just spoke about it yesterday again at the conference call with all the counties. Of those, for aid to localities, 18 reimbursements have been submitted. 13 of those exhausted all the contract funds.
Cheryl, what's the contract? What are you talking about, a contract with the counties?
So each year for the HAVA funds, They were implemented in 2006, and each year, we have a contract, we just have to renew it.
Well, what's the contract? Is it between the state board and the county for the?
We need
for
a
the-
mechanism to pay them. The contract is just the
So does that give us a contract of what they're going to use the money for? And that's their contractual obligation, is if we give you this money, you will use it for this purpose?
It's a reimbursement grant, so
It does outline.
it does outline the allowable and what expenses are not allowable.
So there's a two-step process. First, you enter into a contract for that, and then on the second basis, you'll get reimbursed if you legitimately use your own money for this purpose.
Correct.
Right, and OGS is our host agency, so they have to approve the contract, and then the state controller has to approve the contract, because they release the payment.
And the early voting grants do not need to be extended. Those are different. We confirmed that with OGS. They actually, the eligible expenses for those early voting grants are April 12th, 2019 to December 31st, 2020. And then claim for payments,
So
the
this is-
deadline is March 31st, 2021. They don't need to be
What
renewed.
period of time does that cover then, that the counties can get reimbursed for? Is that last year's early
Last year-
voting, or is it this year's early?
It's last year's, April 12th.
Okay, so this would
was-
have to be incurred during
It allowed
2019?
expenses for early voting through December 31st
From when the
of this
budget was
year.
signed.
And we gave them until the end of the fiscal year, March 31st, to get their claims in and get paid.
I'm sorry.
Last year and this year.
Okay, so if they incur costs this year for 2020 elections, there is money available for them to get reimbursed?
If they have money left over.
If they have money left over.
Correct.
And is there, and as I recall, there was an allocation per county that we approved.
Most counties, as we're seeing what claims we've been given, you know, the counties identified their local costs were far beyond what we made available. So they will tell us perhaps they spent 250,000, but our grant is only 110.
Okay, so we're not fully reimbursing these
We're
counties
only-
for their expenses?
They're identifying what qualifying expenses they had, and we're reimbursing for the qualified expenses under that grant program up to the maximum amount of the grant. So capital is more equipment related. The aid to locality can pay for consumables and people and things that a capital grant can't be used for.
Okay, so is there money that you anticipate being available for 2020 for the same purpose?
There is no new money made available in this budget. The money that is being talked about that was made available last year wasn't in a proposed budget. It was at the end of the budget process. It what came together in the final budget. So we have heard talk about a number. We have not seen, the one house budget bills haven't passed yet. It's a conversation we have with the county boards of election. What do they think they're going to need? It would be very important for them to articulate a number. We have not heard a number from them yet. I know PIO and others have worked, to try and create a list of the expenses that the counties have reported to us from last year. It's been tough. I think we're down to 3 counties are outstanding. I know 2 of them, if I remember. I'm not sure the third.
Albany, Columbia, Nassau.
Have not reported?
So certainly when Todd and I went to the budget hearings, the question that was asked of us is how much did they spend last year? We were at 30 some at that period of time, so it was hard to give them a number. But we're hoping we're closer now. Nassau's a big number, Albany's a real number, Columbia's too. So if we can get that information, it would help us to share it.
And that would be last year's expenditures. Now, last year, there were 2 elections where early voting occurred, just the one. So they only did it for the November. So this year, there'll be 3, right? So their costs arguably will triple,
At least 3.
at least 3. So they'll arguably triple this year
New
from
York
last
City-
year's.
New
So
York
if you
City
took,
with the special will be 4.
so if you took last year's money, you'd have to triple it or maybe more to actually get a.
I would think it would be more than more, because as we learned in the having done this and in our conversations with the counties at those roundtable discussions, they realized that they needed more equipment. What they estimated last year to cover, whether they be ballot marking devices, ballot on demand printers, workstations, voting equipment, ballot marking devices, they all came back and said, I think we need more. And last year we had 3 million voters. This year we could have well over 8 million.
And what was last year's allocation?
was $10 million aid to localities
10
and
and
14 million under the capital. But
24 total.
But they really identified, in many instances, they needed more voting machines, especially if, there are many laws that are being considered to expand the number of early voting sites that need to be opened. That will put pressure on county governments to also need money for additional capital improvements in order to meet it, people, money to help run them. So certainly, articulating if there's certainly a dollar amount, the Association of Counties has sent us a letter, including all of us, and at their annual conference has passed a resolution to urge the legislature to fund the costs associated with early voting in specific and the election reforms in general.
Okay.
Anything else? All right, well then we'll.
League of Women's Voters also joined us in that too while they're sitting here.
They've been very helpful. So next is information technology. William Cross.
Good afternoon, Commissioners. I'll go with projects first. For Campus Vitus, very happy to announce we've actually set a go-live date of May 4th. There's obviously significant work to be completed prior to that date, so we will expect to make a final go, no-go decision by March 30th. In the meantime, we're proceeding with rollout preparation, which includes testing, data collection from the counties, and training materials, outreach, etc.
So
Major milestone.
well, let's just ask, what will happen on May 4th under your scenario?
So May 4th will be, actually the weekend prior, May 4th is a Monday. The weekend prior will be an actual cutover of all existing legacy data from the old system to the new.
So if I go on to the State Board of Elections website and go to financial disclosure, will I see a brand new presentation of financial disclosure reports?
Yes, the whole interface for the querying, for queries and reports and updates on the website. Of course, that's just the public-facing portion of it. But the
Right.
whole back-end piece for filing for treasurers and county interface, et cetera, will all be at that point.
So this is all going to come together at once?
It actually has to. It's kind of the big bang thing.
It has to come together.
And there's a rationale for that date, is that correct?
It occurred to me afterwards, but yeah, let's see the May the 4th. May the force be with you, but yeah.
That was not the reason.
Is that what we're relying on?
Todd and I, and certainly the council compliance unit, since they have the larger list of FIDUS operations with the CAPAS component. We certified the candidates for the June primary on not later than April 29th, and we also wanted to implement this at a time, not at a periodic report where everybody would have to do it all at once. This will at least give us a period of time to test the financial disclosure in time, and also to make sure that we can have the June primary candidates certified under the old system and then go to the new system. So it was a timing issue, assuming everything works as planned. That's why we have
That may be a big assumption, right?
Well,
You know what they say about assumptions.
we meet regularly to review those risks and whether or not we're ready, and that's why if we're not ready on March 30th, that would be the no-go. If we are still on track at that point, it will be a go.
So you're going to know by March 30th, you believe,
Yes.
whether you're ready to
Right.
go? Okay.
That's the real answer.
And doing it for
Gotcha.
the pre-primary it's a smaller unit of filing, so that helps with those. It also allows, because
Starting on May 4th also deals with campaigns. We get amendments quite often, so there'll be a series of amendments always come in, starting prior to the 32-day pre-primary. And it also gives the advantage that right after candidates have got on the ballot, so if they're new to the system, for new candidates, they only go into the new system. You don't have to do one filing in the old system. If we did it in July, there would be a transition period, so this helps with new candidates going in, so So there's a lot of plans and things that do have to go in motion, and that's why we're, sharpening up the go, no-go date for the end of the month.
There's very few pockets of time that actually, there's no ideal time. This is one of the better ones, given where we're at right now in the schedule, so. But
That's great.
We
Oh,
can
by the
taste
way,
it.
that's great.
We
I
can
hope
taste
that's
it.
true, and
I hope so,
looking
too.
forward to it. Yes, yes.
Okay, I'm done.
Go out on a high note.
Online voter registration, we've also had significant progress on analysis and development of the requirements for the new system for the online voter registration and clearinghouse function. We're currently on schedule to go out to bid through the OGS PBITS process in April, the beginning of April. Also, as part of this effort, we've also begun a working group with voter registration system vendors in the 3 counties with homegrown systems in a collaborative effort in working towards this system, because it will require modifications to their system as well. So far, we've had 2 very productive sessions with them, and we're going to continue that cadence. Accessibility, striving to meet our December 31st deadline, IT completed remediation of all primary website content, as well as voter lookup and election night reporting. Upon completion of Campus Vitus, we will be fully compliant across our whole public facing presence. I'll note for voter lookup, we took the opportunity to completely rewrite that application to not only make it accessible but also mobile friendly, so it now renders correctly on all small screens, phones, tablets, as well as standard PCs, because as we watch metrics on election night and leading up to election night, it's been very apparent of what those devices are being used to access our sites, and we're trying to adjust them accordingly. For security, IT and Secure Election Center has worked with almost everyone, executive, PIO, admin, and others, developed the 2020 cybersecurity plan, which we'll have later, for the new HAVA funds. The county board risk assessments, as of this week, all county board reports have been completed and distributed to the counties. New York City's report is also completed, and we're working with them to get it to them securely. Mitigation, as our next step, we're working to define a scope of work to help the counties address the items that are identified in those reports. This includes information security consulting services, or what we call CISO on demand, to help them develop remediation plans to address high risk and high priority items, as well as maybe a potential reimbursement program for hardware, software, upgrades and replacements. Also, to assist in this effort, we've worked with the Center for Technology and Government to create a working group with county IT directors in this effort, and that's also been productive. SANS training, we work with PIO office to release this year's new cybersecurity user training curriculum to the county boards, as well as the county IT that support them, and our own state board staff. The managed security services with our partner Sedera, we've now completed implementation in 34 counties. That was the optional service they could utilize for log consolidation, monitoring, and alerting and things like that. 34 counties took advantage of that, and it's been implemented. So that, along with the intrusion detection and the training, are all on our plan to continue as part of the 2020 HAVA funding. We've also begun planning for a new series of regional tabletop exercises to be held in the July timeframe coming up. Secure Election Center has also started a series of cybersecurity newsletters to the county board. So far, we've released 3 of them on topics of cybersecurity trends, ransomware, protecting elections websites, and we have a new one going, I think, next week for social media. We've received good, nice feedback on those. And as always, we're continuing to work on our own multiple security improvements internal for our infrastructure. This particular period, we made some pretty significant improvements in refreshing our legacy environment, as well as our own security posture internally. Website analytics, pretty normal for a non-election period, about 250,000 views per month on the main website.
Anything else? All right, so then our last report is from our Enforcement Council, Risa Sugarman, who, of course, is not here. So let's just go over her activities. Has she given any reports to the staff at all in the since our last meeting?
No.
And has she met with the staff since our last meeting at all?
No.
And we have not sought to either, but no.
Okay.
I think we had the ones that are regularly scheduled, but that was,
Okay.
I can't remember during December if that was canceled by us or her.
And then I apologize if I'm repeating what you reported earlier, Brian, but have there been any enforcement proceedings started with the hearing officer?
Nope, none in 2020. There were 2 in 2019.
2 in the whole year?
Correct.
Okay. And have there been any criminal referrals made?
They would have to come through the commissioners, and none have been recommended.
None in 2020, none in 2019?
That is also correct.
Last one was 2018.
Okay. And subpoenas issued? Have there been any requests for subpoenas?
There have been none.
None in 2020, none in 2019 at all?
Correct.
And the number of outstanding referrals from compliance to enforcement, can you report on that?
In terms of the non-filer number, I actually did not bring with me the totality of it, but it is in the many, many thousands. In terms of deficiencies, there are 1,319 that remain deficient.
Okay.
I'm sorry, what was that number?
1,319.
And in the last 14 months, she's acted on 2 of them. Is that the understanding?
In terms of it moving through the hearing officer process, that is absolutely correct.
Okay. All right. I think it speaks for itself.
It does, and, as much as I'm troubled by the lack of activity, which I am, I'm also troubled by the lack of accountability. And I think the failure of the Enforcement Council to come to these meetings, to provide any kind of reporting at all to this board and to the public in general of what's going on in her unit is deeply troubling. I think part of the regulation that we approved was an effort to get some accountability of what's going on within that unit. I think we've seen in other areas of government that lack of accountability is a big problem. I think it exists right here. So I just wanted to mention, I think that's another very troubling area here.
Okay. So that concludes our unit update reports. And we'll turn to old business. And the first item on our agenda is the formal resolution to adopt a use of force policy for special investigators employed by the State Board of Elections as required by Part ZZ of Chapter 55 of the laws of 2019. We did adopt a prior resolution on the subject, but this is the formal use of force policy that basically says that Board of Elections investigators are not authorized to use force.
Right. I would move its approval.
All right.
I'll second that.
All right. Those in favor of adopting the resolution, say aye.
Aye.
Opposed? All right. So our use of force policy is adopted.
How is the use of force policy communicated to the people who work in that unit?
Generally, our policies are posted on an internal website for availability to all employees, including commissioners, and communication goes out when a new when an amendment is made or a new policy is added to that list, to all the employees that, here's a copy of it, and if you need another one, it's
Well,
posted in this.
Well, part of this policy says that the peace officers, they don't have, they have their guns taken away from them, correct?
Yes,
We already
at the
did that.
last meeting,
but
and we
You-
mandated in
My
that.
point is, it's on paper. Has that happened?
Yes. Excuse me. In terms of the transmittal of the policy, the last resolution indicated that it was to be delivered to the Chief Enforcement Council within 24 hours, and it was delivered. And
So do they still have their guns?
I don't know.
Well, who's in charge of looking at that?
Ordinarily, we would assume good faith on the part of somebody who receives a lawful regulation by a governing body. But you're absolutely right. Do we have reason to be concerned that your directive may have been ignored?
you want a report, you don't get it. You want this done, you don't get it. Well, why do you think this is going to be followed?
This is
You're right,
one
I
of those
don't.
rule of law questions.
Well, does it make sense for this resolution and the use of force policy be personally handed to each of the persons who has investigator status?
That's two in the agency now, based on the list that you originally voted.
It does.
That's still here.
We can send over a copy.
Now,
Well,
my thing just on the gun, they purchase their own guns?
They're purchased, I don't know if they have their own guns, but generally, we had guns but prior to, so the legacy trade, moved them
But there
to,
are guns.
So,
Perfect.
my point is, this
Good
why I
point.
asked the question.
Yeah.
That's a good question. It's a good question. I mean, obviously.
I mean, this is a piece of paper.
And if we own the guns, we should just ask for them back.
well, the government of the state of New York owns them.
Well, then they should ask for them back. You know what I mean? That's my point.
Excellent point.
Yeah, she should give, when firearms are turned in, there's a,
They go to the state police.
right, there's a specific surplus property procedure for that.
So I think we should ask our executive directors to just follow up on this point, and if there are only two people involved, that doesn't sound very onerous.
Does that include the enforcement council?
Yes,
Choose one of the two.
She wears a gun.
Yeah, it does include her.
Well, that was the first peace officer status that was granted by the board, and then there were others at the time, but only one of those, I believe, only one of those employees is still here. Everyone else is
I don't
left.
think it's particularly onerous for you to approach that other person as well as Ms. Sugarman and to say,
No, we
here
couldn't.
is a copy of the policy adopted by the commissioners.
No, here's the point.
And then if there's a,
Every year,
right,
we all take 13 courses in whether we can put our socks on or whatever, okay? This is a policy. How is it being communicated? So if there is a lawsuit or anything else like that, and they go to court and say, no one ever told me about this, I didn't know about this. So how do we protect ourselves against that?
I agree.
Fair enough.
So,
I
We get your
completely
message.
agree.
We would work
I
with
completely
it.
agree. I completely agree. I mean, we did communicate the prior policy.
Now that we have an adopted
directly to
policy,
them.
we will certainly take care of that.
Okay.
all right, so.
Next are the formal adoption of the procedures for early voting. Does somebody want to just give us a two-sentence explanation, please?
Yes. So this particular regulation has been in place by emergency adoption, I believe on 3 prior occasions. This particular version has some minor changes that are for the purpose of effectuating standardizing when various items under the policy are required to be filed. Some other common sense changes, for example, the deadline for filing early voting site was changed from 45 days before the election to 46 because 45 days always falls on a Saturday and didn't make any sense to have a filing deadline that always fell on a Saturday and roll over to a Monday. And all of the other changes, I believe, are related to standardizing when things are filed and harmonizing dates.
Have you received any comments on the regulations?
The board did receive comments on the regulations. We've responded to comments, I believe, in the last emergency
Right,
adoption.
the last filing, we were required to do an assessment of public comments, which we.
You want to
provided.
summarize that?
There were comments related to, one comment was related to the number of, how to determine the number of sites, whether it's the number of primaries, the number of general enrolled voters, or the number of the party, which number to use. And the comment urged that we use not the party enrollment, but the enrollment of general enrolled voters, and we've determined that that was unreasonable, that a reasonable reading of the statute and its intent would be to use the number of party enrollment. Otherwise, for example, in the SAM party primary, you would require potentially a large number of early voting sites.
What was the argument?
That the statute as drafted required that you use.
You mean it was just a straight reading of the statute,
Right.
not a practical
Correct.
impact?
That was the most substantive comment, from my recollection, that we received.
Okay.
We also received from Disability Rights related to providing enough notice to voters of like when polling hours are open essentially, and we addressed that, and we believe that the regulations sufficiently addressed notice.
Mr. Berg, did you want to comment on the regs?
I'd like to. Hi folks, Jared Berg from Vote Early NY. Thank you for the opportunity. Thank you for all your hard work. And it's definitely imperative that the state and the counties have requisite funding to carry out their many duties this year. On this issue, on this reg, I would describe it as a programmatic wrinkle created by this reg and not in the statute. And it really does go to the determination of how many sites should be required in a primary. And so it's created by this reg in 6211.1B2 by a phrase that does not appear anywhere in the statute. It says eligible to participate in the election, as opposed to, and departing from, the first provision, 6211.1B1, that tracks the statute, registered voters in each county.
One B two?
Right here, yeah.
Yeah, so, and I know you folks are familiar with this stuff, of course, so I don't mean to use shorthand if that's not. But I would urge the board to extend this reg and slightly revise just that phrase rather than do final adoption today. And there's a reason why. For one thing, I do understand the practical goal of the provision in the statute, and I would say it's already available and remains available to the board were they to just follow the statute and keep that standard at registered voters. Because that paragraph says that the board, a given board, can vote, can do a resolution and reduce that number. So that's already available to a given board should they decide in a special or a primary less sites from that required would be.
What are you actually, what language you want changed?
Sure, so in 6211.1B2, there is a phrase that
No, we see where you are.
Okay.
What are you suggesting here?
eligible to participate in the election.
I got that. What's your problem with that?
Well, for one thing, there's no basis for that in the statute. It must be registered voters. The statute itself allows a reduction in a primary, were it to be the SAM party or some other third party. We understand that the goal is economy, resource economy.
Yeah.
So they can already reduce that.
You mean a county board can?
A county board, sure.
On their
County
own.
board already can on their own based on the very language in the statute.
So why is this problematic?
Yeah.
So that's problematic for a couple reasons. One, it's unnecessary because the statute already gives them the ability, without that language, to do the very goal that that would be to achieve, which would be to have less sites available if there were very few voters or a very low interest election and they weren't needed. And actually, since it was brought up here, the idea that a special election could land on the day of a primary, I would suggest that in that case that you are all now facing, that would create two standards on the same day. And common sense would say, of course, since every voter can vote in a special, it would have to be registered voters, and because a primary is a totally different number, you're not going to have different amounts of sites, but you will have board administrators saying, wait, there's no Republican presidential primary, what do we need all these sites for? And that number should be eligible to participate in the election would be what? Only the registered Democrats, and we're talking 1 per 50,000 registered Democrats in a county. So that's like a very practical on our doorstep reason why we shouldn't do that. I would say it's illegal under the statute. The statute says 1 per 50,000 registered voters, and commissioners can agree to reduce that in the case of a primary or special, so long as they can still meet the needs of the voters. That's the law today. That's what it says now. So you don't actually need this reg. I just add one more thing as a policy matter. Of the 16 plans that we've seen so far for 2020 that are public, and of course they're not due yet, so there's a few more weeks for boards to decide what they're doing. Boards actually aren't dramatically reducing and expanding the amount of sites or hours for these 3 election events. They seem to be agreeing with our view that that would create a lot of confusion, and instead they're sort of designing a plan to go the whole way with the permission the statute already gives them to expand and tweak that plan. But in any case, I'd say that we get it. The goal is you need a mechanism to reduce the sites where there to be not that many voters, or a contest where there's only a few voters. They already have that permission. So I'm not sure where this language, eligible to participate in the election, comes from. The statute does outline this, that it must be registered voters. But even in this coming April, I don't see how it's workable. So thank you for the opportunity. I would like to mention something on vote centers compliance, but this is not before the board now. So thank you.
I'm prepared to go with this language as drafted. I don't think we should change it now.
Even
And
with
one
the
of the things.
maximum of 7.
Can I just
counties-
finish?
Oh, sorry.
First of all, I don't think we need to change the language from what's in here now. But in any event, there are many bills in the legislature to change the early voting statute. I strongly suspect that some of them are going to get adopted probably in the budget, and there may be others that get adopted outside of the budget. So we're going to have to revise the regs again anyway.
Yeah, I mean, I'll just say for my purposes, I just don't see any harm in having an eligible to participate standard as it relates to how many voting sites you're going to have, whether it's a special, primary, general. It really doesn't matter to me. I think that eligible to participate standard is a very reasonable one, because that's really what we're talking about, how many voters might show up at a particular voting site for a particular election and need to be serviced by a particular number of voting sites. So I don't see the harm. I mean, you may, I'm not sure about your argument about the technicalities of the way the statute reads, but I just think on a practical level, if you used an eligible to participate standard, I think that's a very reasonable one and very workable. And
Counties could always do more.
yeah, I mean, it may not comport with the statutory language exactly, but I think it gets us where we want to be, which is to have these voting sites based on that number. Those eligible, again, whether it's a general, special, or primary, that seems to me a very reasonable standard.
Bob, I cut you off before.
No, it was the same issue.
Right,
Even if the maximum is 7, counties have done more. So counties can do more if the circumstances of the special being added. I mean, a good example is in Monroe County. The special election for Congress in Monroe County for the 27th is just a corner of the county. So they may have to do something different if they want to cover those two towns, or just like those two towns, there wasn't a site in those two towns before, would they put it elsewhere? But they'd have to look at the totality, and then they added a special for assembly in the same Monroe County. So certainly, there's a number of factors that go into it that I know Mr. Burke has spoke to us here and in our other conversations, that counties have to consider, both transportation, participation, does it make sense to put more in? So certainly the counties know they can have more, and many have endeavored to do that.
Well, and they did designate more. We had well more than 100 sites that were required by the minimum based on the statute and the regulations last year alone. And we don't have the designations in for this year, but as we've said, the legislature is looking at fine-tuning that. So I think the standard wasn't to reduce the sites, the standard was to scale the sites to the people who can participate, the voters that are eligible to participate in the election.
Yeah, I think we're trying to standardize this as much as we can statewide to give equal access to voters across the state. I know I've been somewhat troubled by the implementation of this, because I think some of the upstate counties, because of their far distances, have not had enough sites, really, because people, even though they're not densely populated, are having to travel very long distances to get to these early voting sites, because the statute was based on number of eligible voters, but that upstate is clearly different from a geographic standpoint than it is in the more populated areas. So while there may not be as many voters in some of these upstate counties, they do have to travel long distances to get to some of these sites, and that's a problem that also exists. I know there's been, for example, a piece of legislation that was going to force, I think, counties to put them in their most populous city or town or whatever it happens to be. To me that's all well and good, but you've also got this other issue that doesn't seem to be talked about much, which is, if I live in a rural area, I may have to drive 20 miles or more to get to my early voting site, where the guy that lives in the city has to go 3 blocks. Is that fair? So we can all agree that the number of voters serviced might be the same, but the reality is, in an upstate county, where I'm from, the southern tier, you have relatively rural populations which have 1 or 2 voting sites for a very vast area, and that problem doesn't seem to be talked about much or addressed anywhere. Anybody seems concerned about it, but I think that's a concern we should also be looking at beyond just is the guy in the city getting serviced here? So I think that's something else they should talk about.
Agreed. All right, we ready to vote on this?
Sure.
I'll move it.
All right, those in favor say aye.
Aye.
Opposed? All right, so those regulations are adopted. Next is approval of the school district absentee ballot application. Is there anything controversial in this? All right, so
You talked to the school people, right?
Yes.
Yeah.
I don't know.
This involved conversations between staff of the board and staff of the state Department of Education and the State School Boards Association.
Okay, I'll move that.
all right, those in favor say aye.
Aye.
Opposed? So that is adopted. All right, next is the resolution approving the 2020 cybersecurity plan. And the purpose of the plan is in order to qualify for federal funding, right?
That would be correct. This is the plan that's required to be submitted, as we alluded to earlier in the executive report, of the federal law that passed providing additional grants for cybersecurity, but as well as the improvements of federal election. It's a little over $19 million, plus the matching funds would add to approximately $26 million to make available. The bulk of the funds we are, from the last grant in 2018 and to this grant in 2020, are going towards supporting the counties. We have to do our own cybersecurity, of course, but a large bulk of that gets pushed down to services that we're either buying directly for the counties or providing access to some funds in other ways. For example, the risk assessment that we did on site in every county that we finally finished was something that we paid for, that the counties really had not gotten before, and it's a good value to them. Plus the monitoring services that we're also going to extend out. And of course, this plan, can be amended if we see a need. This puts us in position when the budget is adopted, because the federal funds have already in there. Once the budget's adopted, that will allow us to actually spend the funds, so we can't spend it until the budget's adopted. So, assuming the budget doesn't change, but.
So it's to apply for the money. The last two resolutions would allow to expend funds. The 20% match comes from the online voter registration capital appropriation. So it's certainly subject to the budget passing. There's the wording we put in here. So it allows us to receive and spend the matching funds, which is necessary to qualify for the federal money.
Second.
All right, those in favor say aye.
Aye.
Opposed? And it is adopted. Next is the approval of our legislative proposals for this year. They're basically the same as the remainder. Many of our proposals last year were adopted,
So the 50 chapters they adopted last year wasn't quite enough for us?
No, that was my
53.
point. My suggestion was going to be that we have so many to implement, not enough money or not enough staff, we shouldn't recommend anymore, but I was
Well,
stopped in that effort.
but these are actual.
Yeah, and if they pass, then we will have less money and less staff to implement
Now, a
them.
lot of these have been
No,
on
but some of these are to urge, to reduce the burden on us, right?
a lot of these are old and have been on our,
On our list
are
for
there,
many
are there
years.
new ones that are new this year?
There are.
Three.
So Kim,
the ones in
I'm trying to expose your comments as tongue-in-cheek. You're-
No,
you're-
I was quite literal, actually.
So you think that we should not be allowed to,
No, not allowed. I think that we should have sent a letter that said we don't have enough money and enough staff to do what you've already required us to do.
Well, Todd and I testified to that in November.
Right, so
but,
I was
but are you
overruled.
seriously suggesting that we should not be proposing to eliminate the outdated and costly requirement of certified election results being printed in every local newspaper?
Well, practically, I suppose we should, but realistically, we know that has a snowball's chance in actually getting passed for the various reasons we all know.
Well, it has zero chance if we don't ask.
Is time off to vote in there?
No, I added it. I added it.
Can you talk about that for just a second? So, what are we proposing? I know it's been a big problem.
The only ads that we have in here, two of them, when I was overruled on my letter saying we shouldn't get anything more to do, came from our side, in that the time off to vote, we received, I don't know, hundreds if not thousands of questions and calls and from businesses. The Department of Labor won't help us. Nobody will give us guidance. There's no place to flip this to. Businesses are crazy because now there's 9 extra days and the requirement for time off to vote has been expanded, so they don't know how to do it. So if we were going to recommend things, I would urge that we recommend that we fix that error from last year or confusion and go back. I opened the book in 2010 and that is the proposal that you have that goes back to 3 hours without a loss of pay if the voter does not have sufficient time to vote on election
So
day.
you'd go back to the way it was.
Yeah, because now we have 9 extra days to vote.
Right.
It does a little bit more than that, though, because previously there was a standard in the statute that that sufficiency basically was when you didn't have 4 hours outside of your working time. So this does exactly what Kim said, but I would just, for completeness, note that it removes the definition of what sufficient time is.
No, and that was when we had 1 day to vote as well, that old standard.
but it would still apply to sufficient time on election day.
Right.
So that there
True.
would be, under this, if it were to occur, there would be an entitlement to have enough time on the day of the election to vote. Sufficient time is not defined, but it would continue a statutory right to have sufficient time to
Right.
vote and be able to get up to 3 hours off without loss of pay. to do
Correct.
so.
But it's limited to election day as opposed to the election season.
Well, that's how we interpreted the broader change last year, but, I mean, no one would help us or go on the record with.
I know it's been a big, I mean, I've read a lot of
Also, a lot of
stories about
union
it too.
problems,
People are
school
right,
teachers.
complaining, so that's okay.
And,
It's a starting place for a discussion.
yes, and I think there's a pretty good chance that there will be a revision this year. But, you know,
Okay.
it's not our decision. All we can do is make a recommendation, but I think it's helpful to have a bipartisan, formal recommendation coming from our agency.
I do too. And also with the LLC issue, which I know we've talked about here, that LLCs don't have to disclose their information till the end of the year.
So it's a technical glitch in the
I guess it's
statute.
technical, but I mean, on a practical level, I
I
don't know
hope
what your
they didn't
experience
do
is.
it on
but-
purpose.
But you're having a lot of
Now,
problems.
well, yeah, we're having a lot of problems.
Yeah.
But now it would be to be filed within 7 days of actually making a contribution.
Okay,
And to provide it to the committee to which you provide the contribution,
right.
so that they can do their filings appropriately.
This is a transparency measure. It expands transparency and also deals with an administrative problem.
Okay.
All right, so I move the adoption of
Second.
our election law
There was one
proposals.
more.
And,
Yes, there is one more.
well, may I make a suggestion, though, that the three new ones be moved up to 1, 2, and 3? When we number them?
That's fine by me if that's fine with everybody
Does
else.
that make
That's why they're
sense, though, in
XXX on
terms
there.
of getting people to read them?
Should we keep them in red as well, or should we change the color?
Well, I'm willing
That was
to,
tongue-in-cheek.
I'm willing to
Okay.
authorize our staff to tweak the order of the proposals so that they can make a presentation that they think will be most effective in actually getting the legislature to adopt them.
That's fine.
Okay, all right, but, so with that, let me just ask for formal approval of the,
Yeah, I think we just.
I think you've already moved.
we
Seconded?
moved it, so
all
we-
right, those in favor say aye.
Aye.
Opposed? Sorry, thank you. All right, next is opinion on the sheriff, the proposed advisory opinion. Kim, is this yours?
Well, it's everyone's. A sheriff that ran for election was elected 3 times, that had a bachelor's degree. He thought that he should move on to his master's degree, and after his first election, didn't want to pay for it out of his campaign account because he didn't think he had enough money at that time, or some particular rationale that he had. And now he'd asked if he could retroactively go back and pay for his master's degree that he earned, and for the 2 reasons set forth. One, that changes to your filings have to be made contemporaneously when they are expended, and also it's a conversion to personal use in the staff's eyes of retroactively paying for a degree that wasn't required to hold the office that you're holding, that we would deny his request to pay for the degree. Now, we do understand that there are certain instances where a course or a certification or a CPR or something like that may actually relate directly to the office that you're holding. And this opinion does not address those issues, but this is the degree, the master's degree as a whole, according to the request.
All right, I support the opinion.
I agree.
All right, so move, and is it seconded?
Second, yeah.
Those in favor say aye. Opposed? All right, that opinion is adopted. And then the No Ink e-poll book update. Tom or Brendan, you want to just explain why we need to vote on this?
Well, As part of the language that allowed for electronic poll books, the state board was tasked with promulgating a list of approved devices and configurations for use in the state. We've done so since then, approving not only 3 original systems, but also at least 1 subsequent modification. As I mentioned during my unit report, NOINC, one of those 3 vendors, has submitted a modification to their system to us, which includes both hardware and software changes. We did do the same process that we followed initially, which is we reviewed it for compliance with roughly 150 different requirements that we have. We utilized NYSBOE to do some vulnerability and security scanning of those devices. That information was provided to all of the commissioners, and it is at this point the recommendation of our unit that the new configuration be approved.
Wasn't this a check for the inactive voters too? No?
No. The inactive voters can be handled already. So.
Well, you want to address that because a lot of people have asked us about that, about can they comply with the court order on the inactive voters by having the electronic systems provide that list?
The guidance that was provided to the county is stated that although counties could certainly keep a separate paper list of inactive voters, and that would comply with the court's order, if they wanted to include the information of inactive voters on the same device, that whether or not that was possible. And with the 3 currently approved vendors, all 3 systems are able to follow our guidance, which is to kind of make sure that the inactive voters themselves are distinguished in some way from the list of active voters, and that, again, that there is no difference to the workflow, as I think Brian mentioned before, that the inactive voters follow. So if a poll worker were to find an inactive voter in this list of inactive voters that's supplied, that individual would only still be able to follow the affidavit ballot process.
Right, they wouldn't be able to sign the electronic poll book.
So all they would do, the poll
And
worker...
so that's already done, and that doesn't require commissioner approval?
Correct.
All right, good. All right, so I move the adoption of the resolution on the NOINC update. It's seconded. Those in favor say aye.
Aye.
Opposed? All right, that's adopted. Jared, did you want to say something else you said on vote centers? But
Very
please
briefly.
keep it very, very brief.
Thank you. Very briefly. So the board is aware that 54 of the 59 jurisdictions adopted vote centers, or 62 jurisdictions last year. There are 3 counties, putting aside New York City, that haven't: Albany, Westchester, and Orange. At this point, we're trying to figure out exactly why, because they're required to have vote centers unless there's an exception. In the case of Orange County, they responded to a FOIL saying they didn't have a basis last year or this year that they relied on that for. Westchester and Albany did not respond to the FOIL, but in Albany's case, they had a very successful pilot program for where they had 1 county-wide vote center and then several that were regionalized or assigned. So if that worked well in 2019, the question is, what is the basis that they wouldn't roll that out countywide this year, which the law requires, so long as it's feasible? In the case of Westchester, we know that they beta tested vote centers during the election. That is, they actually had people sort of secretly working for the board go and try to vote at one that they weren't assigned at, just to make sure it worked. I think that's unorthodox, and I wouldn't have suggested that that's a great way to test the system. But to the extent it worked, and these counties are all using equipment that is the same as the other counties that have vote centers.
Could I just interrupt you, that with respect to Westchester, it's my understanding that they are going to vote centers, and you're just saying they haven't told you that yet.
Well, sure, these plans aren't due for a few weeks, and they're not present on the website, and they haven't had a meeting where they've made any announcements.
1 more minute.
That's it. There's 3 counties, and so we think it's important.
And then New York City hasn't done it yet.
That's right, and I put them to the side because there's several technical requirements, and they haven't spoken on the record about those and the challenges there. But the point is that in the case of these 3 counties, they haven't stated a basis for not doing vote centers, so we expect all of them will follow the law this year, but they have about 2 weeks to put out their plans. So we're looking at those issues, and I guess I was wondering if the board has information on those counties. We're thrilled to hear that at least one of them is planning to do vote centers.
All right, Tom or Brendan, do you just want to comment on that? Do you have any more information than that? On Orange
Not that we've
and
received
Albany?
from any of those
Okay.
counties.
All right, great. Next was to just discuss our next meeting date.
I had one more thing.
Oh, I'm
before we-
sorry,
before
Peter,
we
go
break.
ahead.
So I had one more issue I wanted to bring up, I guess, bring it up under new business. So this actually relates to one of the lawsuits that was commenced against this. This is the, that Sam lawsuit that was brought against us. In the context of that suit, it was disclosed in that suit that the SAM is an abbreviation for Serve America Movement, that being the name of the party. New York law has a prohibition in it on using the word American or any abbreviation thereof. It seems to me that that party is in violation of that statute. It's 2124, which prohibits a party from using the words American, United States, National, New York State, Empire State, or any abbreviation thereof. It's certainly my opinion that the word America is an abbreviation of the word American and should not be allowed to be used as a name of a party in this state. I'm looking for the,
You know, the name of the party is the SAM party.
well, according to the lawsuit, it says in the context of it that SAM, an abbreviation for the Serve American Movement, wants, and that goes on to talk about what they want in the lawsuit, but it's their abbreviation for Serve America Movement. So it seems to me the official name of the party is Serve America Movement, and as I said,
Except that it
American,
isn't.
I'm not sure what you mean by it isn't.
The official name of the party is SAM.
On the rules that they filed here, their organization.
And we approved that here, right?
No.
No,
Okay.
we didn't
Well,
do
I will say within the rules, they didn't, I mean, this is the first that's come to my attention that this is their name. I will say in the rules file here, it didn't make mention of this, but now in this lawsuit, that's what they're asserting, is that it's an abbreviation for Serve America Movement. So that's, to me, the official name of the party is Serve America Movement. They must have abbreviated it down to SAM. But if the official name is Serve America Movement and we have a prohibition on the word American, I don't know how we allow that to stand.
Well, my suggestion is we take this under consideration, and we could revisit this next month. I'm not prepared to.
I agree
Vote
with that. I
today.
don't mind taking it, I'd just like to deal with it, not at this moment.
I mean, it just seems to me we should raise it now because it's come to our attention now, at least, my attention, and I think your
raised it.
attention. Well, I mean, I think as a board, though, we have an obligation to enforce the statute as written by the legislature, and this is in violation of that. So if you guys want to think about it, it's fine, I get that, but I do want to raise it because I think it's an issue that needs to be dealt with here at the board.
You know,
one way or
I
the
know
other.
there's no legislation prohibiting this, but you got this independence party on the ballot.
Yeah, that was
And that's
a
right out there.
Well, that's a different issue.
And then you
That
got
was a
99% of the
mistake.
people who vote on the SAM line, or look at the SAM line, are not gonna understand that means anything but SAM. That's the way I look at it. I mean, that's the way I look at it now. I don't mind looking at it just in general.
Okay.
And then the issue between American and America, isn't that a legal issue? I mean, I don't know.
Well, it does say
I
in the
mean, I wrote a court
statute,
on it, right?
it does say in the statute, or any abbreviation thereof. It seems to me that that would cover America as well as American. So I think within the statutory language, it's pretty clear that it's not just American, that it's an abbreviation thereof, which you might argue America is, but I think it's covered, so.
I'm not against this, I'm just.
No, I understand.
I'm just throwing things out there. Oh, I care, you let in 1, 2, 3 parties, that's it, but fine.
Okay.
All right, so we'll at least So that has been considered as new business, and if you want, we can leave it as old business for the next agenda.
Okay.
And we were talking about dates.
You're talking meeting dates?
Meeting dates.
Sure.
I think
We need to certify the June primary not later than Wednesday, April 29th. April 28th is presidential primary and the various specials.
And the last date of file designated petitions is April 2nd. So
April 2nd.
So I think we were tentatively talking about the week before.
24th is the
No, we were
Friday.
talking about April 24th, right?
April
Correct.
24th.
Do we need a meeting in March?
I don't think we
we
need
can
a
work
meeting in
backwards,
March.
but
If you,
We need this
I don't
meeting.
need to meet in
We're
March,
just
but
not
if you
like a
want to meet, we were suggesting Wednesday, March 20. Yeah. That's
Well, it's up
Wednesday.
to you. I mean, I can do it.
But I don't think we need, I don't think there's anything pressing. But if we, why don't we leave that as a tentative date?
The
so we-
25th in case we
block
need it.
that out, and then,
And the 24th, the other date?
Yeah.
April 24th?
so we'll tentatively say March 25th and April 24th, so we keep those dates free.
well, on the
And-
April
and-
date, Laurel, the only concern we have is because of the time frame from April 2nd as being, they don't really
Right.
allow you less than 3 weeks. So the following week, you get specific, general objections, and then it's only a very narrow time period to do all the specific objections. We really do need as much time as we can. But recognizing that
When do you certify?
the 29th is the certification date, April 29th.
But-
So, and I know the day before that is
Well, that
the
would be hard
presidential
to
primary,
get that
so.
many moving parts done in one day
But if
and
we-
certify. That's primary day.
It's just, we may need to consider if we do meet on the 24th, you may need to have it open for
Well,
something
for-
to address on a.
So that maybe we should also block out well, except we could do it by phone.
Right, there may be things that just, the time's tight, that's all I'm saying. I can't guarantee that we'll have everything done by the 24th, because I don't
On
know.
any- Right, there certainly will be litigation that extends beyond this,
Oh, yes.
but
Well, we can control that.
I could
No.
probably do the 28th remotely, and come in.
Well, if you had that and the 24th in person and the 28th remote, that would allow us in the event that we needed a
That would
weekend to
be
finish
okay
the
with
last
me.
pieces of the puzzle.
So you want to do 2 meetings?
Does the state board staff have things that relate to the primary on if we did it the 27th?
27th?
28th.
No, the 28th is primary day. Obviously, you
can't
have
do the
you can't do the 28th.
27th?
You can't do the 27th?
Well, 24th, 27th, that's close enough.
Okay. I mean, I can do any of those dates,
I'm
so-
just asking. I mean, I understand that we really shouldn't do it on the 28th because that's primary
So
day.
why
and we're
why don't
gonna
we
have
say the
other-
27th if that's comfortable with everybody?
That's fine.
Yeah, that would be the best,
Sure.
yes, that would
Yeah.
work.
27th?
Because that would give us the weekend, and that's what we were really
Okay.
concerned about.
And I'm just
You did
asking if
last
that
weekend?
interferes with pre-primary duties that.
Well-
Well, we have
the majority of everybody in the building's energy in that month is to deal with all of the ballot
Petitions.
access. And, I mean, we
Right.
got, for many years, we got by because Congress was separate from everybody else. Putting them all together means we are going to be swamped, so everybody in the building helps.
And
So-
this gives you the weekend to,
We've used those before.
We have.
yeah.
And as far as pre-primary, at that point in the schedule, obviously early voting has begun, so we'll be in the process of early voting. We will be in the middle of our pre-election security check-in phase where we're monitoring the weather and other issues that come up for adjusting for incident responses, so.
That's fine. 27th? Is that what-
27th.
27th.
Monday the
25th is tentative in March,
Okay,
Right.
yes, got it. Absolutely.
but it's tentative.
Yes, but 27th.
27th is okay.
Got it.
If you just want, the next time we have to certify is for the general.
No, we don't. I don't
So
think we need that.
just keep your eyes open for the first week of September,
Okay, well, I will. All right.
in case you're planning.
I'll make a motion, we adjourn unless there's something else.
Thank you. All right, so we stand adjourned.
Yes.
Great.